Hey y'all, welcome to my channel. I am the Loud Little Ducky. Today we are going to go over Gingras' reply in support of petitioner's motion in limine. We have already covered the motion in limine. We have already covered the objection and response to it, and now Gingras has filed his reply in support of the motion in limine. So here we go. Gingras filed 5/13/2024 in the matter of Owens v. Echard, reply in support of petitioner's motion in limine, assigned to the Honorable Judge Matta, and as always, oral argument requested. He always wants oral arguments. So it starts off by saying, this is one main issue in this case. Did petitioner Laura Owens become pregnant as a result of sexual contact with respondent Clayton Echard in May of 2023? That is a yes or no question, and it has nothing to do with Miss Owens' past relationships with different men that occurred years ago, two of which were in a different state, none of which involved a paternity establishment action, and none of which included a finding that Owens actually faked being pregnant. No. But it has come out since then that she has, and it needs to be brought up. And her past is not to say because she did it there, she did it in this case. It is to show that she has a pattern spanning over 10 years, and that this is not the first time. So we don't need to be just giving Owens a little slap on the wrist as Judge Duty does. Actually, he hasn't done. I take that back. She needs to be held accountable, and she needs some strong words of a talking to from a court of law, in my opinion. He goes on to say, to help illustrate the absurdity of Mr. Echard's positions, consider if the situation was reversed. In his papers, Mr. Echard claims Owens could never have been pregnant because Mr. Echard says he had never had penetrative sexual intercourse with her. Thus, the question of whether sexual intercourse occurred may be an important dispute fact. It may also not be an important fact, given that Mr. Echard has admitted engaging in sufficient other sexual contact that, by his own admission, a pregnancy was possible. Mr. Echard has admitted engaging in sufficient other sexual contact, by his own admission. A pregnancy was possible, if you say so. Now assume Owens disclosed she was planning to call 3 new last-minute trial witnesses, women who each claim to have been AR'd in the past by Mr. Echard. But those women don't exist, so they shouldn't even be brought up. We don't need hypotheticals in this case. Your client has created enough hypotheticals. If allowed, this evidence would of course tend to prove Mr. Echard lied about not having intercourse with Owens, and that he has a pattern of AR'ing women and lying about it. This would tend to support a finding the same thing happened here. No. No, it would not. Because, as you have said, just because it happened in one place, it didn't mean it happened in another. Just because somebody killed this person doesn't mean they killed that person. But it might show a pattern if there were convictions and other things like that. Also, none of that exists in this case. So if you had that, sure, bring it on, but you don't. So, but this type of propensity evidence is never admissible to prove guilt. That is exactly what occurred in the recent matter cited in Owens' motion involving movie producer Harvey Weinstein. Yes, it was. Guess who that was in front of? A jury. Guess what's not happening in this case? A jury. It's just a judge who can weigh that stuff because they know the law. He was charged with our 3 women, but the trial court also allowed prosecutors to introduce testimony from 3 other women who testified Weinstein also R'd them. Not surprisingly, given the voluminous evidence, Mr. Weinstein was convicted, but his conviction was overturned by the highest court in New York, solely because the trial judge's error in allowing propensity testimony of the 3 other non-charged victims. You are correct, because it hadn't been charged and he hadn't been found guilty of that yet. Now that he is going to be recharged, he has been He has been found guilty of that crime against those 3 people. So now that can be brought up because it has been proven. And past criminal behavior can be brought in. I don't know if we need all the witnesses, but they can definitely say he has been charged in Los Angeles of R-ing 3 women. They can bring it up in this case. At that point, he hadn't gone to court for it. But now he is guilty of that. He is a guilty artist. We reaffirm that no person accused of legality may be judged on proof of uncharged crimes that serve only to establish the accused's propensity for criminal behavior. At trial, a defendant stands to account for the crimes as charged. Proof of prior crimes and uncharged bad acts are a rare exception to this fundamental rule of criminal law. You know what we don't have in this case as well as a jury? We don't have a defendant. We don't. We do not have a defendant in this case. We have a petitioner and a respondent. We don't have a state and a defendant and a jury. So, maybe, just maybe, from a non-lawyer, of course, criminal and civil are different? Let me know if you're a lawyer, if I got that right. I mean, I didn't go to Law 101, but I'm pretty sure they're different. One lands you in jail, one doesn't. Well, it actually can, if the state decides to bring up charges after what they hear in a civil court. People v. Weinstein, 2024, New York, Lexus, Emphasis added. Understandably, Mr. Echard notes correctly that although Rule 404B does not allow evidence of past wrongdoings to be used to prove current misconduct, such evidence can be offered for other reasons, such as to show motive, opportunity, intent, preparation, plan, etc. The problem, as explained further below, is A, Mr. Echard is not seeking to use testimony from Owens' past relationships for any permissible reason. And B, it is clear this other evidence does not actually establish any sort of motive, opportunity, or plan. I kind of disagree with that, because she brought it up, and she lied in this case, in documentation, and it's been proven that she's lied. So I think it's very relevant. A conclusion which is somewhat hampered by the fact that Mr. Echard has failed to comply with his obligations under Rule 49 to disclose a fair summary of the substance of each witness's testimony. Woodnick did, and he did that prior to May 10th, which is the 30-day prior, and it was the deadline. He disclosed that. And by May 8th and such, you had been emailed by those witnesses personally. Or maybe around the 10th. I don't know when Greg's was sent. But I know that Maraschini's was sent prior to the 30-day mark. But, you know, what do I know? For these reasons, the court must grant Owens' motion in limine and exclude any propensity evidence from 1. Greg Gillespie, 2. Michael Maraschini, and 3 is going to be Matt from 2014. Discussion. A. Respondent has failed to timely disclose information required by Rule 49I. I, Mr. Echard, has failed to disclose the substance of anticipated testimony. You have been told what the testimony is going to be in many different forms. And I told you, do not state this BS because you have been informed of what's going to be said. Among other things, he failed to disclose a fair summary of the substance of the expected testimony of Messrs. Gillespie, Maraschini, and Blank. As noted in Owens' motion at page 3, lines 4 through 6, the entire disclosure as to Mr. Blank comprised a single sentence stating, "This witness is expected to testify about his prior interactions with petitioner, including his personal knowledge about her alleged fabrication of pregnancy back in 2014. Yeah. And your client's the one who disclosed that in the deposition, I believe is how we found out that, which we don't have any of the information surrounding that, because that hasn't been released yet. In his response, Mr. Echard refutes his claim with another single sentence claiming all of this information was timely provided to Laura as early as the second supplemental disclosure statement provided March 29, 2024, respondent at 6:1 through 2. Just one problem. The disclosure statement referenced by Mr. Echard confirms proper disclosure did not occur as it relates to Blank. The entire substance of Mr. Echard's disclosure from his secondary supplemental disclosure statement is shown below, which confirms exactly what was alleged in Owens' motion, i.e., no meaningful disclosure of the substance of Mr. Blank testimony has been provided. And it says, this witness is expected to testify about his prior interactions with petitioner, including her alleged fabrication pregnancy back in 2014 and the resulting litigation. Sounds like notification to me, but okay. Do they need like an airplane to fly by with a banner? Do they need like a cannon? Do they need a singing quartet to come and announce these things? Like, how would you like to be notified? Because apparently writing, they're going to testify about prior interactions, including fabrication pregnancies and the resulting litigation. I would like to know that. As it relates to Mr. Maraschini, the entire substance of disclosed testimony is shown below. Michael Maraschini, this witness expects to testify about his prior interactions with petitioner, her alleged 2 pregnancies during their relationship, and the subsequent litigation. What is particularly inappropriate about these bare bones in the extreme disclosures is that they conflict with the facts as Owens understands them, making disclosures by Mr. Echard all more important. Specifically, the disclosure related to Mr. Blank indicates he will testify about a fabricated pregnancy and the resulting litigation, but according to Owens, there was no litigation of any kind between her and Blank, nor did she ever fake being pregnant with him. Okay, my understanding of that particular case is that there was some kind of litigation, and that maybe a settlement was reached. I don't know, because we don't know very much about that. If somebody does know, please let me know. But I thought I heard somebody talk about a settlement that him and her did. And I don't know if she got a protection order against him or not. Usually she does, so it wouldn't surprise me if she had. But, yeah. She didn't fake pregnant. Thus, Owens simply has no idea what to expect, if anything, from Mr. Blank's testimony. Prior litigation? What litigation? Where? When? This is precisely the sort of trial by ambush the disclosure rules were created to prevent. Trial by ambush is no longer a tactic in Arizona courts. Carl G.V. Echard. No, we know there's not a trial by ambush anymore. But is your client not thinking that a protection order and things like that are not litigation? I mean, is that the legalese that we're using here? That it was a protection order and not like a full-fledged lawsuit? Maybe litigation isn't the exact wording that should be used here. But would it be surprising if there was some court interactions based on what Owens likes to do, bring all of her exes into court and play victim? No. But I don't know what their definition of litigation is. Similarly, the only litigation that occurred between Owens and Maraschini had nothing whatsoever to do with the prior pregnancy. No, but she claimed it, and then we found out it was fake. Rather, in January 2018, Owens requested and later received a DV restraining order from the San Francisco County Superior Court against Maraschini based on her allegations that he was brutally violent. I don't remember that being anything, that he was brutally violent, but okay. During their nearly 2-year relationship, including an allegation by Owens that he slapped me and strangled me during sex on multiple occasions. If you have not seen my Maraschini playlist, I do have one separating it out now. I have 3 parts to that. I will be probably adding more. But I talk about, we know that Owens likes to do anything to get these men to stay with her. Like, she will go to the ends of the earth to make them stay with her. So maybe if Maraschini liked sex a little rough, or she's trying not to be vanilla, did she introduce the slapping? Was she like, oh, why don't we try this? Or did he say he liked to do that and she agreed to it, and then she's like, oh, no, I don't like BDSM, but I agreed to it because it made him happy and I wanted him to stay with me, so I just let him do it. And I agreed to let him do it. And then now I'm going to go and say I didn't consent and that it was abuse. I'm wondering if that's what happened here. Because we know how she operates. Anne smothered me into unconsciousness. These specific statements were set forth in a detailed declaration filed by Owens in California court, a copy of which attached here too is Exhibit A, footnote 1, Notably, the domestic violence restraining order issued against Maricini by San Francisco court remains in effect today, and like all such orders, it can only be modified or withdrawn by the issuing court, which has not occurred despite an offer by undersigned counsel to assist in seeking permission from California court to allow Maricini to testify, subject to Mr. Echard's compliance with the disclosure rules. As such, if Maricini were to have any contact with Owens, including appearing as a witness at the trial, Mr. Maricini would potentially be subject for arrest for violating the restraining order. See Cal Pen Code 273.6. So once again, he is threatening to have him arrested. Unless he wrote this all during the same time period prior to him taking it back. But still, it's a shitty thing to do. I get that he is trying to pull out all the stops, and that's his job as Owen's attorney. But, you know, really? But it's a shitty thing to do, but he is just being a lawyer. And he is zealously advocating for his client. If we can get this one to go away because of his restraining order, then okay. Do I think it's shitty that he wants to put it to an arrest? Yes. Maybe notify the court that he has a restraining order on him, or Owens has a restraining order on him, and maybe figure out a different way. But threatening arrest is the douche move. There's other ways to advocate for your client and keep them safe and not do this. No part of that case had anything to do with Owens being pregnant or allegedly faking being pregnant. Nobody said that case did. It just happened during their relationship, which doesn't mean it's not important. It is important. Just because it wasn't, the pregnancy part wasn't fully brought up, but it was mentioned in the litigation and in depositions. So there you go. Because there was never any pregnancy-related litigation between Owens and Maricini, or Owens and Mr. Blank, this makes Mr. Echard's complete and total failure to offer any disclosure regarding the substance of their testimony all the more inexcusable. That point, standing alone, warrants complete exclusion of their testimony of non-disclosure grounds. As to Michael Maricini, Mr. Echard has also failed to disclose valid contact information for the witness and or has provided erroneous information about the intent of the witness to testify. In his response brief, Echard correctly notes Rule 49I requires both sides to disclose, among other things, the names, addresses, and telephone numbers of all expected trial witnesses, along with a statement barely describing the substance of their expected testimony. As explained above, Mr. Echard has not complied with requirements as to Messrs. Gillespie, Maricini, and whoever else, because he has not provided any explanation, fair or otherwise, describing the substance of their expected testimony. But separate and apart from that problem, Mr. Echard also failed to comply with the Rule 49I as to Mr. Maricini because he has failed to provide valid contact information for the witness, including his current address. The purpose of requiring that information is self-explanatory. Rule 49 requires the disclosure of witness contact information to permit an opposing party to contact the witness, interview him or her, and to serve the witness with legal process such as deposition subpoena if the witness refuses to communicate voluntarily. And okay, like, I can see that needing to happen. I don't think Owens needs access to that. But you know what? Serve his attorney. Because I don't think any of these men want them to have Owens knowing where they live. Because I sure as heck wouldn't. This girl's unhinged. I don't need her showing up at my house like she showed up to Gillespie's house. Here, shortly after receiving Echard's disclosure, identifying Messrs. Gillespie, Maraschini, and Blank as expected trial witnesses, undersigned counsel attempted to contact each witness to determine the relevant information, if any. Each had. The only contact information provided for Mr. Blank was an attorney in San Francisco named Blank. To date, undersigned counsel has been unable to reach Blank despite calling her several times and has received no response from her. As for Mr. Maraschini, the only contact information provided was that of an attorney in California named Randy Sue Pollock. Ms. Pollock was counsel for record for Mr. Maraschini during the part of the restraining order litigation. Undersigned counsel contacted Ms. Pollock to ask about Mr. Maraschini's expected trial testimony. In response, Ms. Pollock indicated Mr. Maraschini was not going to testify at trial, and she refused to make him available for either an informal interview or a deposition. Has she talked to him? Or is it her client won't be testifying as far as she knows? My guess is Pollock is going to be representing Maraschini. He might have retained her again, but I don't know if she's been retained for him for this matter or not. But it just says, it's an email that says Randy Sue Pollock to David Gingras on 5/6/2024. Mr. Gingras, my client will not be testifying, and is signed Randy Sue Pollock. Such gamemanship by Mr. Echard has no place in this proceeding. Who is the one playing games? Because I believe it's your client. His conduct in refusing to disclose the substance of expected testimony from Messrs. Gillespie, Maraschini, and Blank, or refusing to provide accurate contact information for Mr. Maraschini where subpoenas could be served, leads to only one result. They are not permitted to testify at trial due to Ms. Echard's violation of disclosure rules. See Brian v. Rindle, Arizona, in 1994, noting amended civil disclosure rules attempt to change a culture of advocacy in which hiding the P has too frequently been the objective. State v. Reinhard, the underlying principle of disclosure rules is the avoidance of undue delay or surprise. State v. Helmick, the object of discovery is to assist the search for the truth by providing the parties with all the evidence possible so that the crucial facts may be presented at trial and a just decision made. Yes, I agree. Every side should have certain ways. Gingras should have a way to subpoena him for a deposition if he so pleases. And I get them not wanting to talk to him, but both sides deserve each other's discovery and to know what certain things are. And I think being deposed wouldn't be such a bad idea. It wouldn't be a bad idea. For the fact that there would be attorneys there, they could have security there, it would be on the record, instead of what Gingras wants to do all the time is be on the phone and be off the record. So there's more securities and safety measures put in place so that there is no foolery going on. Mr. Echard has not complied with the rules. He has thumbed his nose at them and at Owens. Right to a fair proceeding. No. She has screwed up her chance for things. because she thinks she can do whatever the hell she wants when she can't. And she doesn't like the fact that she's getting caught. Everything does need to be fair. That is for sure. Because we want to make sure that this thing sticks, and she can't do this to anybody else. If Mr. Echard truly believed his witness had relevant information to share, he was required to disclose that information in a timely manner, and thereby provide Owens with a fair opportunity to interview and or depose each witness in order to learn what they have to say. He disclosed the information to you. He gave you the contact information for him. The person reached out to you. You did not email them back because you don't want to talk to them that way. So it's not that they're fully not willing to have a conversation. You just don't want to have a conversation the way that they do, which is on record in black and white. So nothing can be misconstrued. You take what you get. Gingras. Fair opportunity. Okay. Rather than complying with this disclosure, Mr. Echard appears to have actively and intentionally thwarted Owens' rights under rules. The result is each witness must be precluded from testifying at trial. See Family Law Rule 65B 1B. Where party fails to timely disclose information, the court may issue prohibiting the disobedient party from supporting or opposing designated arguments or from introducing designated matters in evidence. B. The testimony of Gillespie, Maraschini, and Blank is not admissible under Evidence Rule 404B2. There is no dispute. Evidence of other acts is not permissible to show the same act probably occurred here. Thus, there is no dispute. It would be improper to permit 3 of Owens' ex-boyfriends to testify. She did the same thing to me in the past, therefore she's likely did the same thing to Mr. Echard. The point of law is so clear, Mr. Echard makes no attempt to challenge it. He doesn't have to challenge it, because that's not why it's being brought in. She had the knowledge and wherewithal to pull this whole thing off because she's done it before. So she can't play dumb like, oh, I don't know how to do that. She has a pattern that she has done this over and over and over again, and it's not a coincidence that this has happened. It is not to say because she did it there, she did it here. No, it's to say she did it in all of these. And here are all the similarities and certain things that are pulled out of each one that intertwine them all. Instead, Mr. Echard argues the dispute testimony is admissible under the exception of Evidence Rule 404B2 because it is offered solely to show things such as motive, opportunity, intent, preparation, and plan. Although Rule 404B2 certainly does allow evidence that fits into those categories, Mr. Echard completely fails to show the challenged evidence actually fits into any of the categories. I.e., the fact that Owens had a conflict with past boyfriends shows she has motive of some kind in this case. A motive of what? To be unhappy again? She makes herself unhappy. Mr. Echard makes no effort to answer that question. Perhaps he knows the evidence of Owens' past relationships does not remotely fit into any of the categories of Rule 404B2. It fits because there is a sonogram that has been used. It has been doctored. Medical evidence has been doctored. Why does that fit in with the other cases? Let's see. She doctored medical evidence with Maraschini. She doctored sonograms in the Gillespie case. There were dating contracts. There were the abortion things. All of it fits together. I don't know why you don't see that, because you've been told over and over and over again. So pull your head out of your arse and get with it. Maybe you will see. This is particularly true given that there are few, if any, similarities between the facts of this case and the facts of 3 prior relationships. Mr. Echard wants to introduce, indeed, as it relates to blank, identified as MM in Mr. Echard's brief, there is literally no explanation of any kind regarding what, if any, Mr. Blank plans to say. Mr. Echard plans no attempt at all to explain how Mr. Blank's testimony, whatever it may be, could somehow establish a motive or a plan on the part of Owens in her one-night relationship with Mr. Echard. There is literally no explanation of this issue at all. He was told by your client that she was pregnant, used it, whatever means, probably brought up abortion, and then they landed in court or was restraining orders and so forth. This is her ploy. It's happened for 10 years with every person she has opened her legs to in 10 years. That's how it goes there. A plan. This has been her plan. And she keeps going further and further and further with each single victim. They all have very similar components. Now, their length of the relationship or hookup may be different. All of those differ. But the fact that every one of them, she has ended up pregnant. She's threatened abortion. There's been coercions of dating that she uses abortion for. And then there is some kind of in-court stuff. Whether it's a restraining order, an order of protection, whether there's allegations, whether it is paternity actions, it is her MO. I don't know how much simpler it can get. He continues to say, similar to the context Mr. Echard discusses expected trial testimony of Mr. Maraschini in a bit more detail, he completely overlooks these key points. The facts and circumstances of the relationship between Owens and Maraschini were completely different from the one-night stand Owens had with Echard, because we're not focusing on the relationship. The relationship is not what we're focusing on. We're focusing on fraudulent medical documents, sonograms, babies, and abortions. We don't care about the relationship portion. People she has had some kind of sexual interactions with, whether they went all the way or to first base, she does this. Owens dated Maraschini for nearly 2 years, 2016 to 2017, whereas she has never actually dated Echard at all. Doesn't mean she didn't try. And she coerced Echard into trying to stay with her. He just didn't. Owens coerced Maraschini into staying with him through her parents and unaliving threats. Makes this another point that says Owens and Maraschini traveled around the world together, paid for primarily by Owens, something that did not happen with Echard. None of that crap is a part of this case. Nobody has brought up that. Nobody is talking about the dating and the links and their relationships. We are talking solely about the pregnancy stuff that has happened in each of these. No matter how it happened, we're talking about the pregnancy during each of these relationships. We don't care about anything else. Owens claimed she was pregnant with Maraschini, and then she terminated the pregnancy via voluntary medical abortion. Facts not present in this case. Yeah, you're right. And you know what? Who else doesn't have those facts? The expert. The mom doc person, because she didn't list Maraschini's babies on her pregnant history to her doctor. Why not? It's a lie right there. The only litigation between Owens and Maraschini involved in matters of DV. That there was no paternity establishment litigation because Owens never claimed to have maintained the pregnancy and never sought to have Maraschini declare the father. Facts not present in this case. Once again, we are not fully talking about that. She still drug him to court. She didn't stay with him, so she got a restraining order to make his life crappy because he wouldn't be with her. So she threatened him, and she did this. In short, far from showing a pattern of highly similar conduct, the facts and circumstances of the relationships between Maraschini and Owens show exactly the opposite. The details from the past bear little, if any, resemblance to the facts of this case, other than the fact that both matters involve Owens and both involve short-lived pregnancies which ended for entirely different reasons. This is why Maraschini's testimony is so clearly improper, because it is not being offered for any admissible purpose under Rule 404b2. It is being offered solely for the purpose prohibited by Rule 404b1. Rejecting argument defendant fraudulent intent in 2006 can be inferred because defendant engaged in many other fraudulent acts over the years with other people. The court sustains defendant's objection to this evidence. This evidence is improper propensity evidence. It is not habit evidence under Rule of Evidence 406 or Rule of Evidence 404b1. Provides that evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show action in conformity therewith. The conduct does not meet the Rule 404b2 exception because it does not establish any of the permitted uses. Evidence of prior bad acts would be excluded. Fundamentally, Mr. Echard's goal here could not be clearer. He is trying to use evidence of what he claims happened to Owens' past relationships for one reason: to help convince this court that the same thing happened here. No. Does it bolster that and prove that she's done this before? Absolutely. She has practice. To allow such inflammatory and irrelevant evidence in a case like this would constitute reversible error as a matter of law. State v. Ricks. Explaining the admission of extensive other act testimony with no limit or extraneous and unduly prejudicial facts allowed the state to luxuriate in inflammatory detail and the result in irreversible error. State v. Salazar. What we don't have is a state in this court. This is family law, not criminal. So the state and your sightings of the state have nothing to do with this. You can take those sightings back. Here, as the proponent of disputed evidence, Mr. Echard bears the burden of showing the evidence is admissible. He has failed to meet the burden because the only purpose of the evidence is to show Owens has engaged in other acts in the past, and therefore she likely did the same thing here. This evidence is per se inadmissible under Rule 404b. It must be excluded. Additional comments. On page 7 of his brief, Mr. Echard briefly mentions a report from an expert named John Berryhill, which purportedly involved thousands of pages of text messages exchanged between Owens and Mr. Maraschini during the time they dated in San Francisco between 2016 and 2017. These alleged text messages, covering nearly 2,500 pages, were disclosed by Mr. Echard just 3 days before the close of discovery, and none of the underlying data supporting Mr. Berryhill's analysis has been disclosed, as is required by Rule 49J. You weren't given a copy of the report prior to the 10th? Mr. Echard offers no evidence or explanation regarding why this voluminous information was not disclosed in a timely manner as required by Rule 49B2B. Similarly, Mr. Echard offers nothing to authenticate any of the messages as required by Arizona Rules of Evidence 901. For these reasons, and based on yet another instance of improper sandbagging by Mr. Echard, Owens intends to separately seek exclusion of Mr. Berryhill's report and the messages appended thereto. Since this evidence was not timely disclosed and still was not fully disclosed, Owens will offer no response other than to say the allegations about what Mr. Berryhill's report says are disputed and have not been independently investigated or verified. Then go independently investigate it and verify it yourself. Conclusion. For all the reasons stated above, the court should issue an order precluding Mr. Echard from calling Gillespie, Maraschini, and blank as trial witnesses. Dated May 13th, 2024. Signed by Gingras. Okay, so that is the motion. Then, attached to this motion is the original declaration for the restraining order against Maraschini. I'm not going to go through that here. We do go through that in the Maraschini playlist. But we are going to go over her declaration for renewing the restraining order, which for the most part has similar details and it lays out most of the same things. There may be some few minor changes here and there, but I don't want to go over two declarations, especially since I've already gone through it on my channel. I will link that particular video, and I will try to put a timestamp on it if I can. I haven't attempted to do that. But yeah, so let's see what the declaration of the renewing of the restraining order against Maraschini says. Now he puts in this long declaration of Owens for the renewal of the restraining order. And you know how I feel about declarations from Owens, because I don't believe anything that comes out her mouth. I do not care what she declares. I, Owens, declare as follows. 1. I make the statements herein of my own personal knowledge, except as to those matters stated on information and belief, and as to those matters I believe them to be true, and if called as a witness, could and would testify competently thereto. Request to permanently renew 2018 restraining order after hearing. In 2018, Maraschini and I stipulated to the court's issuance of the 2-year restraining order after hearing, which expires at noon on July 10th, 2020. Based on Maraschini's violations of that order and my ongoing fear due to both his violations and to the severe violence that led to the restraining order, I am requesting a permanent renewal of that order. A brief summary of incidents leading to the 2018 restraining order after hearing. 3. As I detailed for the courts in my March 29, 2018 supplemental declaration in support of my restraining order request, Maraschini was brutally, here she mentions brutally violent to me during our relationship, in addition to his frequent verbal berating of me, so severe that a complete stranger slipped me a note when Maraschini went to the bathroom during our December 30th, 2016 international flight to Iceland, telling me to run from Maraschini and get help and protection. She later submitted a declaration and agreed to testify at the hearing in support of my restraining order request. He slapped and strangled me during sex on multiple occasions, despite my telling him not to do so and him promising never to do it again, and smothered me into unconsciousness. For, as I detailed in my March 29, 2018 declaration, on one occasion in mid-February 2017, Maraschini held me down so hard while we had sex with me that I was bruised for several days, and then strangled me when I gasped for air. He shoved 2 of his fingers down my throat and called me a good girl when I gagged. I attached photographs to my March 29, 2018 declaration showing the court the hemorrhaging around my bloodshot eyes, which became common due to him strangling me. I went over this in the Maraschini video. I might do a separate video on this altogether. When he smothered me with a pillow while having sex with me around late March 2017, I thought I was going to die, and he told me it was the best sex he had ever had and that he liked controlling my access to air. Several times during our relationship, he demanded oral sex and held the back of my head so that I couldn't move it while thrusting his pee so far down my throat I threw up. Around June 2017, I lost consciousness when he smothered me with a pillow while having sex with me. When I came to, he flipped me onto my stomach and demanded that I get on my knees and ejaculate into my mouth. He later told me that what he had done was my fault. I brought it out on him. I felt completely broken as a human being and hated myself for being with someone who did this to me. After the June 2017 incident, I started avoiding Maraschini and spending less time with him, hoping that would lead to a natural end in our relationship. Instead, he began stalking me. He began showing up places he knew I frequented. He started coming to my house unannounced, even when I specifically told him not to, or when I ignored his calls or text. I detailed these incidents in my March 29, 2018 declaration as well, including the night in November of 2017 when he asked me if I could come over when he asked if he could come over and showed up anyways after I told him no. He banged on my door and yelled my name until I let him in. Oh, she says she let him in because I was worried he would upset my neighbors. In the other one, I don't think she said she let him in. She may have. I may have misread that completely. But she says she banged on the door. And she was worried that it would upset her neighbors. And she opened the door. And then she goes into this statement, says he then began having sex with me. And I was too afraid to stop him. And I was like in the front door, like where the neighbors could see. Like, did y'all go to the couch? I don't think she said she let him in. I'm going to have to go back and see if I just completely misread it. But this is very similar to the exact declaration that she put in the Maraschini case. Like one of her last declarations. In that case, this is exactly that basically. And then she just added parts 1 and part 2. So pretty much everything is the same here. While having sex with me, he told me about another woman he was sleeping with. When I told him I didn't care, he told me it would be a turnoff for him to make me jealous. And then he held me down with his left hand and strangled me with his right hand. This was the last time he had sex with me. He continued to stalk me. On or around November 28, 2017, he texted me that he had been at the bar and in the corner of the restaurant watching me and my family having dinner there. I don't think he said he was watching you. He just was there and saw you. even though he did not live in my neighborhood and told me he was moving to Sacramento. I saw him at least 10 times within a 2-block radius of my apartment between December 2017 and the end of January 2018, which I detailed in my March 29th, 2018 declaration. She says 10 times in 3 months. Wait, December... 10 times from December to January. So 1 month she saw him 10 times in a 2-block radius. He says he saw her a couple of times, but he has reversed it to saying she was stalking him. And what she fails to mention here too is that his sister also lives in that 2-block radius of her apartment. So if he's spending time with his sister here and there for whatever reason, he might run into her because she goes to those different places all the time. And granted, she only goes to like the same 3 places, it seemed like. But I don't know who was stalking who in this situation. I feel like 10's a little exaggerated. She fails to mention that his sister lives there in that area. Yeah, she's leaving out some key points because they don't fit her narrative. He's supposed to be in Sacramento, yet he's all the way over here in my neighborhood. That's what she wants to make it seem like. And that's not what was happening. I had been going to Barry's boot camp gym around the corner of my house daily since before I started dating Maraschini. Throughout our relationship, he made fun of me for going in. In December 2017, Mr. Maraschini joined that gym, even though he did not live in my neighborhood. Well, maybe he was going to start working out with his sister. Him and his sister were going to hold each other accountable. And that was like the cheapest one. And maybe he thought he was going to be moving to Sacramento, or he was just going to be staying there because he was going through some shit because his stepfather had passed away during the middle of all of your nonsense. Seriously, if you have not done his story, I will have the link to the playlist in the description box below. Start with part 1 and continue, and then continue from there, so that you know his story. I finally filed a request for a restraining order after an incident on January 8th, 2018, while I was walking home from having dinner and encountered Maraschini and his sister less than 1.5 blocks from my home. They stood in front of me, which prevented me from walking past them. No, it didn't. And screamed at me. When I pulled out my phone to call my parents, his sister yelled at me, "Don't you dare get your phone." Oh, she's saying she was calling her parents. In another declaration, she stated that she was calling the police. And they kept her from calling the police. And guess what happened next? Maraschini, after this interaction, went to the police because this interaction was about the fact that Owens had contacted Maraschini's girlfriend at the time on Facebook. She went and found that and reached out to her to talk crap about Maraschini and warn her how abusive he was. And that's not stalkerish. If you want to warn somebody, great. Do it. Maybe it will save them. More than likely, it won't at the time, but when things end, they might come to you. Because, I mean, how often do we want to listen to someone's ex because we're like, oh, they're just bitter, they want to be with them, like they're lying, and then maybe later you found out they weren't. But to me, if that was the case, I feel like his girlfriend at that time would be out here backing Owens. Like, oh, I know Owens is telling the truth about this because I dated Maraschini too, and she tried to warn me, but I didn't listen. But that hasn't happened. That woman is not out here standing by Owens' side. And that would have been something that bonded them after Maraschini and that girl's relationship ended. Because I don't think that's who he's married to now or with. But anyways, that is why this. But let's leave that out here. Like, why are they mad at you? Do they have a reason to be mad at you, Owens? Possibly. Number 8, Mr. Maraschini violated the temporary restraining order, which I detailed in my March 29, 2018 declaration. For example, on January 28th, he posted on Instagram that he was at De La Rosa across the street from my house. He also went to Barry's boot camp around the corner from my house on at least 2 separate occasions, while the TRO was in effect. Why are you on his Instagram? Get off his Instagram. Block him. Stop stalking his Instagram. Number 9. In July of 2018, Mr. Maraschini and I stipulated to the courts an issuance of the 2-year restraining order after hearing. Incidents since 2018, restraining orders after hearing. Number 10. One of the restraining order's terms, to which Mr. Maraschini agreed, was the standard 100-yard stay-away order, prohibiting from him coming within 100 yards of me, my home, my workplace, and my vehicle. I understood that part of the reason he was willing to agree to this restraining order was because he was moving to blank in blank of August of 2018. It gave me more peace of mind to know that he would be living more than 25 miles away from me. I was reassured by his move and by the restraining order that he would not be in my neighborhood and would not be anywhere near my home. On July 16, 2018, less than 1 week after the issuance of the restraining order, my parents told me that they had seen Maraschini in my neighborhood. Through my lawyer, I communicated with Mr. Maraschini's lawyer that Mr. Maraschini was violating our agreement and the order. 100 yards is not an entire neighborhood. And if his sister lives in that neighborhood, it's not a violation. On information and belief, his attorney said that Maraschini had been buying a bed nearby. Yeah, maybe his sister found him a bed on Marketplace or something. Oh my God. 12. On 3 different occasions in 2018, after the restraining order was in place, our mutual friend told me that she saw Mr. Maraschini around my neighborhood. Does she have pics? Are there pictures that he was around the neighborhood? Like, it's so ridiculous. I'm trying to see here. Let's see. We've got... So basically, a little smaller than a football field. That's not an entire neighborhood. Like, it just doesn't. It's not as long as a mile. He can be a mile down the road and stuff, and he's not breaking the restraining order. Two of my friends from Barry's boot camp gym who knew about Maraschini and knew I had a restraining order in place told me that on 2 separate occasions in late summer or early fall of 2018, Mr. Maraschini had come to Barry's boot camp, the same one Maraschini knew I went to daily before and during our relationship. They expressed concern for me and surprise at having seen him there. Notice this is her friends saying this. And notice that that Owens was not in these places. The only thing that restricts Maraschini from anything is that if she is there, he cannot be there. That is it. Like, your friends running into him does not mean he broke the restraining order. It just doesn't mean that. And the fact that a judge said that it did and signed off on it because of these instances is ridiculous. On one day around the beginning of April 2019, some friends from the same Barry's boot camp gym where I have taken over 980 classes told me that Mr. Maraschini had once again come to the gym. They said he didn't work out, but he just came in and got a shake at the fuel bar refreshment counter. You know what he's... Oh, someone sent me a screenshot of Maraschini's Instagram post. Okay, so she's saying she didn't look at his Instagram post. Somebody sent her that. So maybe he just likes their shakes. I don't know. Maybe there's... I don't know if there's another shake place, but maybe they have a specific type of shake. I don't know. But you weren't there, so why did it matter? Copy which I'm attaching to this declaration. The gym is approximately 300 yards from my home, around the corner from me. While I realize that is farther than 100 yards away from my home, I can think of no reason for Mr. Maraschini to be at the particular gym around the corner from my house, that he knows I go so regularly, other than to be near me at my home. Everything is not about you. People can go places. There are neighbors with restraining orders. And guess what? They live in the same town. It's just so ridiculous. So he's violating this restraining order, but like, why would he be somewhere? Why would he be somewhere 300 yards from my home, except for to have something to do with me? You're so full of yourself. He represented that he was moving more than 25 miles from my home. He made fun of me throughout our relationship for going to the gym. He did not even work out when he went to the gym on that day in April 2019. He got a drink. He got a shake. Did he not get a shake the other times? Just that time? Maybe that's what he's going in there to do. And I still don't buy that he made fun of her for going to the gym. Because he seems like he's somewhat of a fit guy. And knows that she's skinny and fit and she likes to work out. I am sorry, I do not buy that he made fun of her for going to the gym. Like, maybe he was like, girl, you don't need to go to the gym because you're fine just the way you are. I like your body. Like, maybe that's what she means by he made fun of her. Like, he was joking with her about her body was great and she didn't need to go to the gym. One day during the summer of 2019, my mom told me that she saw Mr. Maraschini at the restaurant about 1 block from my house. Is this Mama Noku? Once again, you weren't there. Your mother saw him. He's not violating the restraining order. Another time in late 2019, my mom told me that she saw him getting into his car a couple of blocks from my house while she was driving to pick me up. So maybe he was leaving his sister's house? which is a couple of blocks up the road from you. Also, not within 100 yards of you. In mid-January 2020, I saw Mr. Maraschini at a restaurant, Della Rosa, which is across the street from my home, well within 100 yards from my home. When I saw him near my home, I panicked. I felt paralyzed, and I didn't know where to run to or what to do. I was afraid of whether he would approach me, harm me, or make a scene. I was flooded with horrible memories, and I felt back to square one, fearing for my life. Did you call the police to say, hey, I have a restraining order on this guy, and he's here? Granted, if she walks into a place and Maraschini is there, sadly, because she's the one with the protection order, Maraschini has to leave. So he should have left the restaurant when he saw her, which sucks, but it is meant to protect people who actually do have real reasons for restraining orders. That if you walked into a restaurant and you had an abuser that was there, you would want them to leave. And you are the one, like, you don't have to change your life because of somebody else's actions. In this case, she abuses the legal system, and he does have to change his life because of this person's actions. But usually it's the abuser who has to do the things and change his life and live, within these restraints because of their past behavior. But notice she didn't call the police. She didn't make a police report, nothing. Did he see you? Like, I would like to know about this event. One day in early May 2020, while both blank and San Francisco counties were under strict shelter in place orders due to COVID-19, I was walking to the pharmacy on blank nearby my home when I saw Mr. Maraschini right across the street from my house standing in line for takeout at Della Rosa. Okay, so he was at Della Rosa's in January of 2020. He went back to Della Rosa in May of 2020. He was wearing the green Patagonia jacket I gave him, and he is very tall and has a very distinctive look, so I was certain it was him. I was with my mom, whom he knows, and I saw him turn towards us, and I believe he saw us. When I saw him, I was very scared. I began to have panic attack. I said to my mom, that is Mike. He's not supposed to be here. I understood that Mr. Maraschini lives in another county, so I was shocked to see him right outside my house for any reason. Why are you shocked to see him outside of your house? If you have seen him and he hasn't moved and stuff just yet. Maybe he moved back. I don't know. I would love to hear Mike's story or see the files of his rebuttals on this stuff, but I don't have those. But I don't understand why she's shocked if her friends and her have saw him all these millions of times. Was shocked to see him when the shelter order was in effect due to COVID. When I came out of the pharmacy, I saw that he had walked across my street and was walking with another man directly in front of my apartment. So he left? And he was with somebody else, not just alone? Maybe he was getting food and then going back to a business meeting or something. Maybe that was his sister's boyfriend or his, brother-in-law or something. I yelled out his name to let him know that I knew he was violating the order. Maraschini, I will get you for this. You're violating the order. Wait till the judge finds out. He did not turn around, and he kept walking. I was terrified he was not taking the order seriously. I felt threatened and unsafe. So he left from where you were at, when he saw you. He ignored you and didn't talk to you. But you felt threatened and unsafe. Right. Okay. Gotcha. Mr. Maraschini's brutal and repeated violence against me during our relationship, and then his stalking of me when I tried to get out of the relationship, have caused me severe psychological distress. Wasn't he trying to get out of the relationship way before you? Because that's what I seem to remember. And your parents having to beg him to stay with you, but you ended the relationship. Okay. I have been diagnosed with PTSD, anxiety, and depression. Anxiety and depression, I believe. PTSD, I have not seen any doctor's reports or heard from any doctor that has stated that you have PTSD. I also don't think that I have seen you mention that to your expert or to the mom doc when you talk about medical history. So, do you? Because what do you have PTSD from? If this never happened. If it did happen, I can understand. But where is the evidence that you had been diagnosed with it? Because I think that is important for the Maraschini case. That she's lying about that, possibly. Since he did all the things to me, I struggle to have intimate relationships. Yet there have been many victims of yours since then. Okay. I sleep on my couch to avoid being in my bed where he hurt me. So for 2 years, you have not slept in your bed because he hurt you there. But half the time, you've said that he did things to you on your couch. The first time he strangled you, and when he came to your door unannounced. Or he said he was going to come over and you told him no and he just showed up. That happened on your couch. So why are you able to sleep on your couch and not in your bed? Because in your story, he hurt you in both places. Don't go back to Iceland either because he hurt you on those beds. Don't get back on that plane because he hurt you there. Like, stop with the lies. Like, if this story was real, the story itself would be enough without giving extra details. Stop making it sound worse, because it's already bad. Like, you don't need to throw in these other things that aren't true just to heighten your story. Because real victims, their story is enough. It is what it is. But you add sleep on my couch to avoid being in bed where he hurt me. When we also know he hurt you on a couch, supposedly. He hurt you in Iceland, supposedly. He hurt you on a plane, supposedly. But you can be near all of those places. So give me a break with that and stop lying to judges. Even if your story was true, that statement right there is not. I stopped going to my favorite restaurants out of fear that he might come there. No, you didn't. That's proven by your own words in a declaration that I covered in the Maraschini series. I'm not going to get into the rant of that because I did it there. But that's a lie. She didn't stop going anywhere. I have frequent flashbacks of his hands around my neck and not being able to breathe or scream, and him violently arming me. Every time I leave my apartment, I look over my shoulder, expecting he will grab me or push me or strangle me. except for the only time that he ever supposedly did something to you was during sex. Not any other time. He didn't grab you out in public. He didn't push you or strangle you anywhere other than during sex. Not even during arguments. It was just during sex that you say he did this. Which is why I think maybe some rough sex was consented to. If it wasn't, don't be doing that. But notice, she never states that he did this stuff to her when they fought. Like when they fought on that airplane, they didn't go back. They didn't get off the plane and go to their hotel room and him do anything to her there once he found out about the stranger letter. He didn't grab her by the throat and push her up against the wall and say, da-da-da-da-da, now, people know about what I'm doing to you and you're going to really get it. No, it was during sex. He didn't even do these aggressive things during arguments, which seems odd. Now, is there a DV abuser out there that maybe just does it during sex? Possibly. I'm sure, maybe. In R-ing. But usually they're abusing you at other points too. They're not just saving it for that. I don't know. I have not been in that situation particularly. I've had other issues that are kind of adjacent to it, but I haven't dealt with somebody like that. I carry pepper spray. I really never want to have to use it. I have a psychiatric service dog, and I live in fear each and every day. Where's the service dog certification? And is Mr. Buttons the service dog? The one that is old and you say Maraschini threatened to punt and he was little and he couldn't control his bladder and whatever else was wrong with him? Because Mr. Buttons has a restraining order against Maraschini as well. He can't go in 100 yards or 10 yards or something of Mr. Buttons. Because I don't believe that's a psychiatric service dog. And a psychiatric service dog, I'm thinking, is her way of making an emotional support animal sound more important. Like she's trying to say it's a service dog, but it's actually just an emotional support dog. And she could need one of those. Like, I think she should have a support dog as a companion. At least somebody will love her. Because right now, nobody wants to. Except for her parents. And nothing against emotional support animals. I do not have my little dog registered as an emotional support animal. Do I think she is? Absolutely. I think she helped my mother when my dad passed. She puts people in a good mood. If you've had a bad day and you see her, she makes you happy. I am not going to get the certification for things. She also helps my son with like anxiety and things like that. It makes him feel safe. But I don't need a piece of paper to tell me that. And my dog went through no training to be that. She just is that by being who she is. But you would think if she had a service dog, they would also be trained into dealing with seizures. Because she has those, apparently. But if Mr. Buttons is this, I don't know if I buy this. There is another dog that I don't remember if he came before or after Mr. Buttons. But Mr. Buttons is the dog that she got while she was with Mr. Maraschini. We talk more about the dog in other videos. I can't even imagine what Mr. Maraschini would do to me if he caught me alone. Nothing. Nothing. Ignore you like he did before. Like, he's not done anything to you anytime that anybody's ran into him, or you have happened to be at the same place as him, or him be at the same place as you. Nothing has happened. And you've been with your family, or he's been with somebody, and you've been alone. Like, there's all the different situations of being with each other, alone or not alone. All those situations have happened, and nothing has happened. I see a therapist regularly. I take medication for PTSD and depression. Now, if she is saying that her depression is also for PTSD because certain depression medications can be given to people with PTSD as well, but since they cover both, she's just saying she takes it for both when she doesn't have both. She's twisting that truth. I have undergone extreme cutting-edge treatments for PTSD. I don't know what treatment she's done. Has she done hypnosis? Like, what has she done? And still, we don't have anything that from an actual doctor that says she has PTSD. And I can't believe her. I would love to believe her. I would love that people wouldn't lie about this. But I can't believe a word out of her mouth because of all the lies she has told. In the last 2 years, I have spent approximately $75,000 of my own money on therapy, specialists, and treatment to heal from what Mr. Maraschini did to me so I can move on. My doctors have told me that the treatment has not worked sufficiently to address my PTSD. Where? Turn that over. I request the court issue a permanent renewal of the restraining order. Without a restraining order, I would never feel safe again. I live in fear of Mr. Maraschini every day of my life. He may not look like the kind of person who would do dangerous, lethal things, but he repeatedly strangled me and suffocated me to within seconds of my final breath. So she's stating he tried to kill her. I have suffered from depression, anxiety, and PTSD, and even after significant treatment, I am terrified every day because of what he did to me. I have spent 2 years trying to recover, but that has not been enough, and I am not healed. He has not stayed away from me, and I don't think he will ever leave me completely alone. The thought of not having any protection from him and the thought that he might be allowed to come near me is terrifying. I can't live with that kind of fear. I know the restraining order has angered him. It has. It has. Because he doesn't believe that it should be there. He doesn't believe he did anything to get it. And if he didn't do anything to you, and he has one, I would be angry too. But real abusers, it angers them, but usually with real abusers and real stalkers and people like that, they don't care if you have a restraining order or not, because they're going to do what they want to do. Which doesn't, I'm not saying all, there are some that might follow the restraining order and wait till it's up. But Maraschini has not shown to be anything like that. I am scared he harbors even more resentment towards me. Oh, he does resent you. For many, many things. As he should. In my opinion. I don't want to have anything to do with him ever again. Except I want to talk to him. Original signature on judicial council form. So that is what Woodnick put in this thing. Let's put out this declaration of all these different things. And he's saying, see, nothing about pregnancy was mentioned in here. It is mentioned in her original declaration about her being pregnant. And so, but it's not mentioned in this one. So I don't know why, but yeah. So what do you think? That's Gingras' new filing. Ending out this video with our quote of the day. Lawyers have feelings too, allegedly. Do we think Gingras has feelings? Like human feelings, not robotic feelings? Like, does he have empathy and sympathy? Like, it really will be interesting to see him battle in court. If that is streamed. To see if he's as aggressive in his oral arguments as he is in writing. Or if he's more chill and laid back and not like that. He's just making this his persona right now on the internet. But if you like this video, hit the like, subscribe so that you get to see more videos in the future, and I will see you soon. Bye.